During cross-examination conducted by Nnamdi Kanu's lawyer, Kanu FG, before Justice James Omotosho, the witness said that the recovered items may not be ordinarily offensive, but the intention of the defendant. The DSS operative admitted analyzing the cell phone of the defendant, but the report of analysis was not made available to the court because it is immaterial. In the 10 years that the items were impounded, he admitted the properties may have lost their value and become of no use. He further explained that he did not bring anyone before Kanu to confront him on any issue of terrorism. Mr. Kanu's statement was obtained without the presence of his lawyer, and the statements were not obtained from other persons. There is no other person put on trial by the federal government on account of agitation for Biafran nation actualization. The witness said that he read in the newspaper and social media those backing the defendants in the agitation. He admitted that there were killings in some parts of the country, especially in the north, but the government had been doing its best to stem the tides of the killings. The witness said he would not also know whether the killings were as a result of self-determination agitation.
Our senior reporter, Celestina Area, joins me on the news for more updates. Celestina, what more can you tell us about hearing in the case involving leader of the indigenous people of Biafra, Nnamdi Kanu?
Oh, well, about today, so far so good. The trial is going on very smoothly, and considering the evidences given by the first prosecution witness today, so far nothing incriminating has been found against the the leader of IPOB, which is Nnamdi Kanu. So we don't know what is to come as the proceedings continues, and we don't know for sure how many witnesses the federal government is going to call. This is just the first witness, and he was cross-examined today by counsel to Nnamdi Kanu FG, and wherein he made some findings that Nnamdi Kanu was interviewed without his lawyer present, that most of the items that were seized or collected from him in 2015 have no value anymore because it's over 10 years. But Justice James Omotosho told Kanu FG, which is counsel to Nnamdi Kanu, to come by way of application before the court seeking the release of some of those items, wristwatches, gold chains and necklaces, and see if Mr. Kanu can peradventure sell them and get something out of it. But so far so good, they have no importance. So it will not of any good for either the prosecution or the defendant for those items to still remain in the custody of the court, because now they are exhibits. So the court adjourned to 6th, 7th and 8th for continuation of trial. So the conclusion of the cross-examination of the first witness to be done and the second prosecution witness to be called.
All right. You mentioned a while ago that it's unclear how many witnesses the prosecution would be calling. But does it appear that the others might also enjoy this liberty to testify behind screens?
Yes, definitely, because this is the position the court has taken, and it was because of the application filed by the federal government lawyer saying that to protect the identity and the life of the witnesses, they should testify behind the screen. The prosecution first witness, which the court named Mr. AA to protect his identity, testified behind the screen, and when he even walked up to the dock where he was shielded, he wore a mask. So, but basically, one thing is important: the defendant, which is Nnamdi Kanu, can actually see the witness, but the person, he or she, is shielded from the floor of the court, which are other lawyers and also litigants and journalists. But the defendant, Nnamdi Kanu, can see whoever the prosecution witness is. And this is the first witness. He is a DSS officer. He was among those that arrested Mr. Kanu in 2015, where he was interviewed. And also he said he was among those who escorted Mr. Kanu to the headquarters here in Abuja.
Celestina Area for us in Abuja. Thank you very much.